In today's video, we're going to talk about how to respond to debt collector lawsuits. This is going to be step by step the things that you need to watch out for when preparing your response to a debt collection lawsuit. And I'm going to also start off by saying that if you need help with a debt collection lawsuit, the links are below this video, or you can go to my website, thecreditrepairshop.com, and you can type in live chat and you can upload your court summons for a review. We will tell you the options that are available to you, and but we'll do a review so you can kind of get some answers to what you're going to be dealing with. So when we're talking about a debt collection lawsuit, something that we need to go over, and I think it would be wise for you to acknowledge if you're dealing with a debt collection lawsuit, is how do we get here? Like, how do we get into the situation of having a debt collection lawsuit? A lot of times I hear people say, I don't know, it just came on my doorstep, or someone knocked on my door and handed me this, court document saying that I'm being sued. Had some people just say all of a sudden they were being garnished out of their bank account, or they were being garnished from their paycheck. And I'm like, well, there is a process that they have to go through to get to that point. And so what I want to review real quick is that process. So if you are we're going to have a solution for you if you are already getting sued. But I want to go over this process because the foundation could be getting laid for a debt collector to come and sue you. So this video is actually important for people who are not being sued also. But it's more important for the people who are getting sued, because you want to know what you can do to stop or to have a chance of winning your debt collection lawsuit. So how do we get here? The first thing is that you're going to have an account from an original creditor. And if you have not made payments, depending on what type of account it is, for 3 to 6 months, they're going to take it off the books. And when they take it off the books, it's the term for that is charge off or written off. The misconception is that when an account is charged off or written off, the creditor gets to write it off on their taxes, and it's like they get the money back. And no, that is not true. Yes, they are writing off the amount against other revenue that they've made, but they're not getting money for your account that they're writing off, that charge-off account. So after 3 to 6 months, they're going to take it off the quote-unquote non-performing accounts book. These are accounts where they're receiving monthly payments. They have to take it off of there and make it a charge-off so they could be compliant with the banking regulations or lending regulations, state regulations. That's why they have to do it. When they do that, yes, it puts a mark on your credit, and it's going to lower your credit score, because it's going to state that you have an account that has a balance that hasn't been paid. So the next thing is, depending on the type of company, credit card company, or if it's a payday loan, or maybe it's like a dental place that, did loans on dental surgeries or teeth and whatever it is, that creditor would sell those loans, quote unquote, unpaid loans. And it might be a company that was financing the customers for a certain company, like the dental company. They're going to sell that portfolio. 9 times out of 10, most of the companies will not sue for themselves. They will just sell it. They're not in the business of doing that. The companies that are in the business of suing also are American Express, Discover, Barclays, Bank of America, Capital One. Those companies, more than likely, and bankers, there's a few, the list keeps adding on, but those companies will sue you directly. For the purposes of this video, what we're doing is we're focusing on debt collectors who buy your debt and they come to sue you. So they're going to package these credit card companies or, lenders are going to package it all up, sell it to a debt collector. It's like it's going to be all of them. They don't sell it one at a time. They're going to just package it all up, sell it all at once to a debt collector. Everything that the debt collector gets at that time is all that they're going to ever be able to get, unless they have a special relationship, which most of them don't. The companies are like, hey, we sold it to you. You don't need to come back to us with anything. You've always just did what you've done. But what I'm going to have you do as a solution is going to be the reasons why they're going to wish that they were able to go back and get more information. And also, so moving forward, so they're going to sell that portfolio. They're going to sell that portfolio, which is all of those accounts, to a debt collector. Some of the debt collectors, what they'll do is they'll sell them to other debt collectors. Some debt collectors will, package it all up and send out the demand letters, which is the next step in the process. Is they're going to send out a demand letter, or if they sell it to another debt collector, they're going to do the same thing. So the next step in the process is the debt collector is going to send out a letter that looks like a bill, but it's really a dunning letter. That's the term for it. And in this dunning letter, what they're basically doing is they're telling you, we bought this debt from your original creditor, whoever that was. They're going to identify that company. They're going to say that this is our file number because we own the account now. This is who we are. And then they're going to say inside of that letter, which they better or they would be non-compliant, is that you had an opportunity to dispute any or all of the debt that they're claiming that you owe. They're going to also give you the opportunity to pay. So you could end up paying without challenging, without validating anything. You could have the opportunity to pay, because when you technically pay it, you're saying that you agree with all of the information that they have in there, even though they're giving you the opportunity to dispute. So if you do not respond to that letter, the next thing that they're going to be able to do, so if you don't respond to that debt collector dunning letter, the next thing that the debt collector is going to be able to do is to place that information on your credit reports. So now you don't have just one with the charge off from the original creditor, you have two negative accounts. One of them is from a debt collector. Now the debt collectors, this is a sneaky trick that they play to try to get your attention. First, they're going to put that account on there. And in some cases, I've seen, and when I say cases, I mean in some instances, I've seen where the individual's credit did not drop. And this is what makes people not worry. Like, this is done intentionally to make people not worry, but it's to get your attention that you have to do something about it. They came up with this strategy. So what they'll put it on there as it's a new account. And we all know if you add a new account to your credit, some of the times it might even let your score go up, but it'll usually keep your score neutral, or it'll only go down just a little bit. In the past, what the debt collectors used to do is when they bought your account and they sent you the dunning letter and you didn't respond, they would put it on there as a full-blown negative account, collection account. Now what they're doing in some instances is that they put it on there as a new account, and they will not put the label that it is a collection account. Now, anyone who looks at your credit will know from those company names that you have a collection and you need to do something about it. I've even seen where they had green on there like you're paying on it. Now, the next thing that they do, if they can't get your attention, like, hey, we just put it on there, we're still giving you the opportunity to deal with this, but you need to respond to us. And they're going to try to reach out by mail. They're going to reach out by email. They're going to reach out by phone. They're going to reach out by text if they have the ability to be able to text you. And if you don't do anything about it, the next thing they're going to do is, this is what is like the double whammy that hurts people, and this really gets people's attention, is that they're going to label it as a collection, and then your scores are going to drop 20 to 40 to 60 points by them doing that. And it's like, this is crazy, but this is a tactic that they've learned to use, because they try to get your attention. They know that it's not going to make any movement, and if you end up resolving it, they'll be able to take it off your credit, no harm, no foul. But if they don't get your attention and you don't do anything about it, and then they come back the next month when they do their reporting, they label it as a collection and do what they're going to do with the other information on the data lines, your score drops 20, 40, 60 points. Now, there's no rhyme or reason behind why it could drop that much. I've seen people who have perfect credit and they get one collection on there and it drops 60 points. And I've seen other people who have bad credit and they have another collection on there and it only drops like 20 points. So I don't know. That's the algorithm, the way that they put that together. Now, the majority of the debt collectors will choose to sue. And let me tell you the reasons why they will choose to sue. Is that they know, just from past experience with dealing with people's debt, people who they have purchased their debt from the original creditor, debt collection companies know that they don't have to worry about too many of those people showing up to their court hearing, that they're going to basically get default judgments on about 99% of the people. It used to be like 95%, but now it's the numbers just keep going up. With all of the information that's out here, with everyone that's trying to help people, 99% of the people are not showing up to court and they're getting default judgments. Or a large percentage of people are showing up without any defense against what the debt collector has presented in the court. And there has been court I don't want to say an investigation on the court, but investigations from the ACLU, investigations from there was a judge, like a judges association, and they state that most of the time that debt collectors present information in court, they don't even have the proper documentation. Some of the documentation is from other cases. Some of the information is just totally not even pertaining to the case, but they cannot just outright say that. They have to be impartial. And so they just end up giving people judgments, because all they have to do is, if it's not challenged, if you don't challenge the information that they present in court, you're going to lose. And if you don't show up to court, if you don't even show up to court, you automatically lose and you get a default judgment. And so they make a lot of money. They're going to end up being able to garnish people's wages when they win the debt collection lawsuit from a default judgment, or if the person goes there with no defense and they get the default judgment, or they get the judgment, period, they're going to be able to do these things. They're going to be able to garnish the wages, or they're going to be able to garnish the bank account, or in some instances attached to personal property, or liens, or put liens on stuff. Like it's going to open the door for them to be able to start trying to collect money. So what I want to go over real quick is a short list. And there's obviously more things that could be done, but that's going to be on a case-by-case basis based off of what they present. But in most of the debt collection lawsuits that I've viewed, these are the number one things that I would look for and I would challenge to set up an affirmative defense for someone. And this is what you can do for yourself. So the first thing that we want to do is we want to ask for written permission for them to even have your personal information. You want to know, how are they able to get access to that? You might be saying that they could just get it by buying the debt. Technically they cannot. If that was true, why would you have to sign these constant terms and conditions changes that these companies make, where they'll say we got to change to our terms and conditions? A lot of the changes to the terms and conditions are you signing over your rights to, if the debt goes bad, if the loan goes bad, that they could just pass it over to a debt collector with no problems. No one used to challenge this stuff until I came up with this, with this question, with this defense. Now, they may provide it or they may not. But if you're going to have any chance of winning, you need to have everything out there. Just like the debt collector is going to throw everything out that they have on you, you need to have some sort of defense to counteract what they do have and what they don't have. And one of the things that I don't see is they never have any information that shows that authorize them to be able to have access to your personal information. Now, I have seen, I would say one time it was sent where they did outline it in yellow that said that if in the case of this debt going bad, that we could, if we sold it to another company or another servicer, that they would be able to have access to your personal private information. I have seen that one time. Another thing that you want to do is you want to get them to provide some sort of contract that you have between you and the debt collector. Even if they don't have it, even if they never will produce it, you want to have that question out there. Because you're giving the judge something else to have them go and try to figure out, what's the link between this relationship specifically with this individual. Because they're going to try to throw out a whole bunch of stuff, which I'm going to get into in a second, to try to, be like, hey, they were in this batch, so they're automatically, we got a relationship with them. That's not good enough if you push hard enough. Next thing is you want to get the full account number. The full account number. Let's just think logically some reasons why we want a full account number. Well, I want a full account number so I can know that that's the right account number to match with this account. Maybe I had multiple accounts with this original creditor. If you own the debt, this is yours. You're making these big claims that you purchased a portfolio, that you're the owner. Your chest is out big. Well, provide me the full account number, because if I was to go to the original creditor, they would give me the full account number. It is usually redacted by the original creditor, not redacted by the debt collector. Next thing that we want to do is we want to make them prove how they came up with the claimed amount. Now, this is harder to do if you're dealing with one loan. If you're dealing with just where you took out a personal loan and they gave you $25,000, it's going to be difficult to challenge that, but you would still have a right to get a full accounting record of the payments and everything that you made on that account. They have to get it. You have a right to review that. Now, if it's a credit card account, because you've charged, paid, rewards, interest rates were changing, all these different variables that happen when you're utilizing a credit card, you really need to, just for your own well-being, just to calm your own mind, you need to get all of that information. In my own situation that happened to me when I was 18 years old, sorry about that, 18 years old, I got a credit card, and debt collector bought the debt, and they claimed that I owed $4,500. I just down deep knew I didn't owe $4,500 because I was in the United States Army, and I knew that I did not get a card that was going to give me $4,500 at the age of 18, only making a little close to $600 a month in the United States Army. And I was a private at that time. So I knew, but let's just think about it. What if I didn't know? Like, I just knew because I knew. I didn't know how much I had actually had, because it was so far. By the time they came to sue me on it and purchase that debt, the time, like a whole bunch of time had passed. But I just knew that it wasn't. I was just like, it's just impossible. But a lot of times people don't know. Like, you could legitimately say you do not know. That is a legitimate, truthful statement. And just like I said, I said I know I didn't owe $4,500, but I don't know the amount that I did, leave them hanging with that I didn't pay. And it ended up being somewhere around $150. That's how much it was. But the debt collector tried to come after me for it. So you have a right to get all of that information. You have to push on this, though. They are trying to make this very difficult to get an answer to that question. They will go all around the world and not give you what you're asking for. Now, if you're dealing with the original creditor, yes, they will be able to provide those documents. But I've even seen that even dealing with the original creditor, they don't even want to do it. They're like thinking to their attorney that came to them with their chest sticking out saying that we are the best debt collection attorney in the world. We can always collect it. Don't worry about it. We're going to collect your money and you give us our piece. They had their chest out high, and then you ask them that question, and they go back, and the original creditor is like, man, you never had to do this. What's going on? Don't you have enough information to prove the case? They owe us the money. Get us our money. That's how they're thinking. But they didn't expect you to ask them that, and you have a right to ask. Even if you were still a client of the original creditor, like let's just say nothing went wrong, you could still get a full accounting of all of the charges and payments, interest rate adjustments. You could get that snap. Where do you want to send it? In the mail, or do you want us to send it by email? Whatever way. But they're going to get it to you. But see, they don't want you to think that way. They want you to just always be afraid and thinking about what they're doing to you instead of what you start to do with them by asking them questions. The next thing is a bill of sale. You want to make sure that they give you a bill of sale. I'm seeing a lot of these debt collectors getting sloppy again, and they're not putting that bill of sale in there. But even if they put the bill of sale in there, the bill of sale never has the individual's name on there. And then there's other problems. If you read the bill of sale, there's a whole bunch of stuff. I can't even go into it in this video, but there's a whole bunch of stuff that you need to pay attention to in the bill of sale. You can look at the bill of sale and find out that debt collector was not the debt collector who purchased the debt. So they are taking the word of another debt collector for everything that they're stating in their case. The next thing is there's a conformity document, which states that they got all of the documents properly from the original creditor. Now, so if they're saying that they got all of the documents from the original creditor, they can basically only state that the documents that they got from the original creditor were right. But they want to leave an impression that they got all of the documents properly from the original creditor. So I'm going to restate it. The conformity affidavit is going to say that they got all of the records, that all of the records that they got from the original creditor have been maintained and properly stored with their company. But the thought process that they make people think, now there's what they say and what they want you to think. What they want you to think is that they got all of the documents and that it was all done properly and we got everything that we need to bring this case about in this court, this debt collection case. That's what they want people to think. That's what they want the judge to think. That's what they want you to think. But what it is that they just got the documents that they got, and that they whatever way that they transmitted them, whatever they did, it was done the way that it was supposed to be done. Has nothing to do with having all of the documents. It just says the documents that they got, everything was done the way that it was supposed to be done. And they're signing this affidavit stating that. But they make it look like they got everything. See, it's what they want it to look like. So you would challenge that document. That would be in your affirmative defense, even if they did have it. If they don't have it, then you already got a leg up, because you're going to be like, they didn't even put this document in there. You know, that's required of them to do, and they didn't put it in there. If they do have it, then you're challenging it on another level, which is all of the documents. which you will know that they don't have all the documents because of what they put in the court summons. They're not going to put all of the documents. So the next thing we want to challenge is the 1099-C. Reason why you want to challenge the 1099-C is from experience. First, I'm going to tell you from experience side, and then I'm going to tell you from a practical side. From experience side is I've seen personally where people were being sued and an original creditor had actually did a 1099-C, so the debt was forgiven. The IRS expects that amount of money to be included as income in their taxes, and then you have a debt collector coming behind trying to collect on the debt. These types of mistakes happen, but these types of mistakes, they don't get looked at as potential mistakes because no one challenges. If you don't show up to court and you don't even know, some people don't even know when they get a 1099-C what it even meant. Like, I got a 1099-C from this original creditor, okay, and then you're getting sued by a debt collector who bought the same debt. It does happen. It may not happen to you, but it does happen. I've seen it with my own eyes. It does happen. So what I tell people to do, even though you're going to put it in your response, is that you want to make sure that the original creditor and also that no debt collector that has had their hands with the debt, and you want to outline each one of them in there that they have not filed a 1099-C. That brings, thinking about that, let me tell you a story about, this is a real story, true. I see this a lot with Lending Club. They'll have a whole list of all of these trusts. Trust this, trust company that, this portfolio, or this finance company. Like, all of these companies signed off on the sale of that debt. So you're going to tell me that, and this is no joke. This is the truth. One response that we assisted with had I think it had 7 pages of trust companies that had to sign off on that one charge off. So you're going to tell me that none of those trust companies, 0, did a 1099-C to get a full write-off, or is it a portion? Or did this trust company, like, say the person borrowed $10,000, did this trust company get 1,000 and that one gave 1,000, that one gave 1,000, that one gave 1,000, or did these two give 2,000? We don't know. We don't know. And they don't outline that. They just give you the documents. They say all of these trust companies signed off on the sale of this debt to this debt collector. And none of them filed a 1099-C even for a portion? None of them? Every case that came from those types of sales, from multiple trust companies or the Lending Club, 100% were dismissed. Because you're gonna go into court. See, they never expect people to challenge this. They never expect people to challenge it. But you go to court. You go to court and you're suing an individual, and you say that 7, 8 pages worth of companies participated in this one loan, and you're going to say that none of them filed a 1099-C. Those cases when that was challenged. Now, it has to be built with everything, though. But that specific, when you have something like that with that group, where they have all of these different companies participate, not in the lawsuit, they just participated in the loan. I don't know how. And then they have to give that document that every one of those companies signed off. I hope that you're imagining this. Like, imagining, I want to, this is so important. It's so important. Everybody talks about, you know, what how it doesn't seem fair when certain people are getting sued, and it's easy for other people to get convicted. And what makes it harder for the people who win their cases? How they made it harder for the plaintiff, for these debt collectors, is that they walk down every potential defense and described the reason logically behind the defense. Not trying to be some attorney, none of that. Even a good attorney would say, I have to set up a defense, and I have to describe that defense, and that defense needs to be logical. And if it's not logical, it just doesn't make any sense to anybody. But if it's logical, it opens the door for a lot of good things to happen. The next thing that in our affirmative defense that we're going to challenge with debt collectors is we're going to also make sure that they did give you a dunning letter. There have been cases where they did not present a dunning letter, and even if they did give you a dunning letter, let's just say, because I talked about that earlier, they did give you a dunning letter, you still want to get a copy of that because you did not know the things that I teach you about what to look for on the dunning letter. Things like, I'll just name a few of the things that you should look for when you get the dunning letter. And again, a dunning letter, what is a dunning letter? Dunning letter is a letter that you get from a debt collector who has purchased your debt. And it's a letter that is giving you the opportunity to dispute any or all of that debt that you had from an original creditor that they purchased. So number one, it needs to have that you can dispute any or all of that debt. The font size needs to be the same, consistent throughout the whole document. The document cannot be sent to you by an unauthorized third party because they cannot share your information with an unauthorized third party. Now, they're going to upload it in the court, but you can look at it to see if it was sent, because usually in those letters, they're going to have some coding on there, and you might be able to see that it was sent with that return address, because what they like to do is to save money, and they'll fold them up, and it'll have it in the window, the return address, and it'll have your address in the other window. So you want to pay attention to that. Font size has to be the same. And then just any other irregularities that you might see. That's why it's important when you get the documents, you review them. That's why it's important when we tell people, hey, let us review your documents, because we're looking at the issues that we've seen before, and also looking at and evaluating any issues that are specifically pertaining to your debt collection lawsuit. All right, so please like this video. Please share this video. Post them in the comment section. I do my best to answer as many as possible. If you need help with a court debt collector lawsuit, there's a link below my video. If you just know you want to go ahead and have us work on it for you, if you're being sued by a third-party debt collector, or if you want us to review your court summons, go to my website, thecreditrepairshop.com, and in the live chat, you can upload it. That's where it all starts. Let us review it. We'll, tell you what we see and how we can help. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video what makes us different, so you can see my 8-point validation process, my 2-phase settlement process, and to repair your credit and increase your scores. If you don't have your credit reports, go to the website your3scores.com. Links are below this video. If you have debt collectors coming after you early, grab my 3-pack of letters. Statute of limitations letter for debt that is past the legal statute of limitations to collect. debt validation and cease and desist collection activities letter. Those letters can stop potential debt collectors from coming after you in court, but even if they do, you're going to have a head start on building your defense against the debt collector. Thank you for your time. Please subscribe to the channel. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.